Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflict or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
You's a clown, that's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh?
I'm not gonna call
Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Got it?
Good morning, everyone. Happy Saturday. Yeah, that video has nothing to do with what we're talking about today, but it's still funny, and I'm still just going to play it just because I like it. Good morning to Ray Bishop, Cupcake Z. I still am a little, trying to get over this bug, but it's coming along. I feel better than I did yesterday. I may sound worse than what I feel, but we're going to get through this today. Good morning, TD, Ben Childs, of course, Cupcake. Thank you so much to all of my mods that are in the chat. Andrew Carr, Willie Brown, Sharon, P. Holland. Thank you so much. You guys make sure you like, subscribe, and share. I am going to talk about Tory Lanez today. We have not talked about him in a while. I believe his sentencing was supposed to be Tuesday, but there's rumors that it's going to be postponed. So I don't know, but your girl not flying all the way to California just for it to be postponed. I've done that before, and I'm not doing it anymore. So if there are any rumors that it may be postponed, I'm not going. But the Tory Lanez trial has had so much drama this week. It is unreal. So first, we're going to talk about some of the issues that have happened with the bloggers. And then we're also going to go into some documents. So when I say documents, drama, and denial as the title, that's exactly what it is. It's documents, it's drama, and it's denial. So for those of you that don't know, Tory Lanez is awaiting sentencing. He was in trial last December. I was present. Check out all of those videos. He was convicted of all the counts that he was charged with for the shooting relating to Megan Pete, also known as Meg Thee Stallion. So this week, okay, let me go back. So like I said, I was present for the trial. It was a 2-week trial. I was there from day one. I didn't start till the afternoon, so I did miss the morning. But I did see like Meg testify and everybody after that subsequent too. But the atmosphere was so different. Thank you, Ray Mel. Thank you for the super sticker. I appreciate you. The atmosphere when I was there was just so weird. So you had YouTubers or bloggers that came, but then you also had investigative reporters, which are real, journalists. And there is a difference. So most of the YouTubers and the public that came to see the trial, they were Black. A lot of the reporters were non-Black. So there was almost like a divide. I got along with everybody. I talk to everybody. I go kick it on that side of the hallway and kick it on that side of the hallway. Well, apparently there was a lot of different beefs that occurred even between who is the viable blog, if YouTubers are viable bloggers with information, or if you should just go over to the reporters excuse me. And you guys probably seen some of that play out on the internet, play out on social media. So there were two bloggers that came that are pretty, pretty known, that people know. And prior to the last hearing, we received an email, because the courts tell you that you cannot record in the building. There's signs, no recording, no photographs. Apparently, they were accused of recording in the building. So we all got emails basically saying, before the next hearing, we need to acknowledge that we know the rules of the court. So everybody kind of acknowledged it. Well, apparently these two individuals, they were advised that they couldn't come back. So I believe in their minds, they thought that they can come back, just not as a reporter. You can't come back as media, rather, because we were all considered media, had a badge, whatever. They come back, these two bloggers come back, and then they're advised that you can't come into this courtroom at all, not even as the public. So they thought we can come back as the public and not as the media. So they were like, you can't come at all. So they did videos about this, and people assumed who may have told on them for allegedly recording in the building or breaking the rules. And so that became a big drama situation. So it was more drama outside of the case than it was in the case. So this week, yeah, you guys probably know who I'm talking about. Don't put names in the chat. But so this week, I'm just minding my business on Twitter. And then I see this tweet, and this is from Dennis Byron. And Dennis is an investigative journalist. You guys may have seen me come on his platform. And yeah. So he says, breaking, according to my Los Angeles sources, an arrest warrant has been issued for a blogger for alleged threats made relating to Tory Lanez case. This is the developing story. So of course, I pick up the phone like, bruh, who you talking about? Like, who is so so invested in this case that they would make a threat to the point where the police feel like an arrest warrant should be issued. Of course, Dennis is the investigative reporter, so he's not gonna give his sources. So he basically said Pam kick rocks. I'm not telling you who it is. So apparently every blogger and asking the same question. Like, well, who you talking about? Who you talking about? So all Dennis would tell people is it ain't you. I knew it wasn't me, because this case, as you guys have seen, I reported it non-biased. I don't really care either way. I didn't know who I knew who Meg Thee Stallion was from one of the songs she had, but I definitely didn't know who Tory Lanez was at all. My kids were the one that told me who Tory Lanez was. So I ain't have a dog in the hunt. I didn't care. I was really there trying to gather all the information, and based on the information that I gathered, I will report to you guys. And we kind of knew what the outcome was based on the evidence that was presented, and Tory was eventually found guilty. But apparently there are some bloggers that are very passionate about Tory Lanez. Usually when I was talking about Tory before, I would tell the mods to be on point, because they would come in the chat and basically hashtag free Tory and act all crazy in my chat. So then, of course, you see the second tweet. According to my sources, the alleged threat of violence was made using a computer device, and the alleged victim believed the threat was serious. So then he says threats aren't protected under free speech, even if it is a joke. So basically, even if you're playing, he's letting you know the sheriff department ain't playing. So this is the drama leading up that allegedly there is an arrest warrant for some blogger out here because they're making threats, because they must be so pro-Tory that it's worth risking it all. I just want to let you guys know on this platform, it just ain't that deep. It just ain't that deep for me. And I used to love Tupac, but I don't think I would get arrested for him if I went to his trial, if he was alive. It ain't that deep. So if I find out who they're talking about and who is all involved in this, then I'll let you guys know. But this is just to let you guys know the drama that has been going on related to this case. This is just an example. And it's no different than the drama that has been brewing related to the actual case itself. We all know Tory was convicted. He was supposed to be sentenced in January, but then he changed attorneys to get Jose Baez, who represented Casey Anthony, in order to represent him on a motion for a new trial and other motions. I'm going to be honest with you. I don't understand why all of these motions are being filed. In my personal opinion, this is just my opinion. Let me put my little disclaimers because I don't want nobody coming for me. But in my personal opinion, I believe that some of these motions are just to get money. That's just my opinion. I don't understand why all these motions are being filed and they have no chance in heck to even be granted. To me, it's just a waste of money. And the resources, I don't care how much, I don't like taking clients' money. That's just who I am. Are there attorneys that may do that? Of course. I just feel the motions that have been filed are just ridiculous and delaying the inevitable. But we're going to go over some of those motions. But first, I know you guys heard that the prosecutor recommended a certain amount of years for Tory Lanez. But first, before the prosecutor did that, the prosecutor asked that sentence be allowed to be at the higher end of the sentencing guideline because of what we call aggravating factors. The jury was asked do they believe they were aggravating factors, and in the courts, basically the jury said yes. So I'm going to show you guys this document that was filed requesting that aggravating factors be allowed. Again, the aggravating factors essentially allows you to, and shout out, I have to say, Megan Cuniff, she gets a lot of these documents and she allows you to download them and all of that. So I have to give her those props. I'm sure you may have seen her. She was there as well as an investigative reporter. She is on the Shade Room, post a lot of her information. Like she would tweet what was happening at the trial and they would post her tweets. That was another issue. A lot of bloggers felt like, why was her stuff being tweeted and posted? Well, she can tweet her own stuff, but why was it being retweeted and posted? But there were actual bloggers that were there. They had the same, or if not more information, and their information was not being. So that was another issue. So they had an issue with Megan Cuniff. She's never done nothing to me. She was all right with me. She was doing her job, in my opinion. But anyway, so the prosecutor was asking for aggravating factors. And let's see what they said. They said on December 23rd, 2022, a jury found defendant guilty of count 1, assault with a semi-automatic firearm, count 2, having a concealed firearm in a vehicle unregistered, and count 3, discharge of a firearm with gross negligence. Additionally, the jury found true the defendant personally used a firearm in violation of Penal Code Section 12022.5a and personally inflicted great bodily injury upon the victim in violation of Penal Section 12022.7a. Following amendments to Penal Code Section 1170 by way of Senate Bill number 567, the court in its discretion may impose a sentence not to exceed the middle term, except when there are circumstances and aggravation of the crime that justify the imposition of a term of imprisonment exceeding the middle term, and the facts underlying those circumstances have been found true beyond a reasonable doubt. So before this penal code was amended, the court was not to exceed the middle guidelines. However, if you have aggravating factors, you can ask for more than that. It's in the court's discretion to get more. What the prosecution was trying to do was to go beyond that middle range and to ask for more years for Tory Lanez, or Daystar Peterson is his real name. Okay. The people filed an amended information alleging circumstances and aggravation pursuant to California rules of court arising out of the same operative facts related to the crime, which were proven beyond a reasonable doubt at defendant's jury trial. Defendant requested to bifurcate and waive jury as to the factors in aggravation. The people intend to file a sentencing memo. We have the sentencing memo too. I know you guys heard that the people ultimately asked for 13 years. We have the memo which outlines why they asked for 13 years. So let's go to the circumstances why the people believe that Daystar Peterson, aka Tory Lanez, should be sentenced beyond that middle range and be in the upper range, so people can understand why. The crime involved great violence, great bodily harm, threat of great bodily harm, or other acts disclosing a high degree of cruelty, viciousness, or callousness. On July 12, 2020, defendant shouted at the victim to dance bi, pointed a gun in her, and fired multiple rounds, striking both of her feet. And this is parts of the transcript that they're quoting. Defendant was upset that the victim had insulted his music career. Without any justifiable provocation or reason, defendant fired several rounds at victim in the middle of a residential neighborhood. During the late evening hours, victim suffered gunshot wounds to both of her feet and was bleeding profusely. Bullet fragments penetrated both of her feet. Victim was placed under general anesthesia and the fragments were removed during surgery. Removal of the foreign bodies, bullet fragments, by Dr. Little and Dr. Haruno required additional cutting into the victim for adequate debridement of the fragments and cleaning of the tissue. From victim's right foot, victim had a 1.5 centimeter wound from which doctors were able to remove a large bullet fragment. From victim's left foot, doctors removed 2 fragments from a 4x4 centimeter wound. Given the extent of her injuries to her left foot, victim was missing the top layer of her skin. The injuries and resultant surgery would produce permanent scarring to both of her feet. Smaller metallic, sharp note, or fragments that could not be removed without risking greater harm to the victim are now permanently embedded in her feet. So she still has fragments that are in her feet that they could not remove. The seriousness of the injuries required overnight post-op monitoring at the hospital. Had the wounds been left untreated and larger fragments unremoved, there was a risk victim would be symptomatic and suffer persistent pain and or infection. The victim went through physical therapy for several months, received stitches, and was in significant pain nearly a year and a half later at trial. Victim testified that she continues to suffer from nerve damage and experience soreness, particularly when she has to perform as part of her work. Y'all see this? I'm just saying, this is what I was reporting when some people were reporting other stuff. Exhibits introduced at trial in Peoples 26, 27, and 34, and 35, and 36 further prove victims' extensive injury, surgery, and post-op treatment. The evidence that defendant's crime involved either the threat of great bodily harm or actual great bodily harm was overwhelming, and ultimately the jury agreed when they found true the defendant personally inflicted great bodily injury to victim beyond a reasonable doubt. Defendant's actions are demonstrated a high level of callousness. As victim began to walk away from defendant wearing only a bikini and no shoes, defendant mocked victim with dance as open fire in her direction. With no justifiable reason, defendant fired not just one, but up to 5 rounds in the direction of victim in the middle of a residential neighborhood. The act not only directly inflicted great bodily injury to the victim, but posed a significant danger to everyone in the vicinity of the shooting. The brazenness of defendant's conduct is alarming, but the conscious disregard for the well-being and safety of all those around him signifies a high degree of indifference for human life. California rules of court. The defendant was armed with or used a weapon at the time of the commission of the crime. Defendant fired a semi-automatic firearm in the direction of victim 5 times. Immediately after the shooting, the gun was found at his feet, warm to the touch and in a slide lock position, indicating the defendant had fired every round from that gun. Let me read that again. Immediately after the shooting, the gun was found at his feet, warm to the touch and in a slide lock position, indicating the defendant had fired every round in that gun. The victim was particularly vulnerable. And People v. Smith, the court held that particularly vulnerable is not vague and particularly means in a special or unusual degree to an extent greater than other cases. Vulnerable is defined as defenseless, unguarded, unprotected, accessible, assailable, or one who is susceptible to defendant's criminal acts. And People v. Eves, the court found no error in aggravating a sentence on the basis that the victim was particularly vulnerable, where defendant without apparent motivation or provocation from a rear seat in a moving vehicle shot the victim twice at point blank range, and where victim was unaware of defendant's possession of a weapon and could not protect himself from defendant's actions, even though victim was a healthy police officer with firearms within reach. The court rejected a narrow interpretation of particularly vulnerable to be applied only where victims' personal characteristics such as age, handicap make them vulnerable. Rather, the court has found that circumstances surrounding the crime, including the time of day or location of the offense, may render a victim particularly vulnerable. So the people, in applying this case law that I just read to the facts of this case, says the victim was dressed in only a bikini, shoeless, and on foot in a neighborhood completely foreign to her. It was late at night. She was unarmed and completely defenseless. She was not in possession of her phone or her belongings. As she walked away from defendant, unaware he was armed with a firearm, defendant fired multiple rounds at the victim, striking her bare feet. She was afforded no opportunity and was in no position to defend herself, find cover, or shield herself in any way. Besides an argument in the car, there was no justifiable provocation or event that would have signaled to her the defendant would have fired a gun at her, not just once, but 5 times. Victim was taken entirely by surprise. Given the surrounding circumstances, she was particularly vulnerable. Based on the foregoing, the people respectfully request that the court find true beyond a reasonable doubt the circumstances and aggravation pursuant to the California rules of court as to defendant. So for all those that were wondering why they were asking for this high amount, this is why. Yes, emptied the gun at that woman, and people say he didn't do it. This was the evidence. See, this is my issue. Now I'm going to go on my little diatribe for a few minutes. My issue with this case is I see a lot of people windmilling for Tory, and you can like them. You could feel like this case didn't have the evidence you wanted. I've heard people say it was no DNA, it was no this, it was no that. But what did they have? They had evidence. They had more evidence than the defense had. The defense did not present anything. We don't care about your theories. The court does not care about what we as lawyers say. The courts don't care about speculations. They care about what you can prove, not what you can say. There was nothing. The defense did not put on a case that would show that all this evidence that was presented on Meg's side should be discounted, or on the people's side. It really wasn't her per se. It was the people that brought it. So I get it. Maybe the case should have been tried different. Maybe there was more evidence that should have been presented on the defense side. Maybe they thought it was so weak that they didn't have to present evidence. I don't know what their strategy was. I don't know. But what I do know is based on being a person that was sitting in that courtroom, they just had more evidence. I mean, they proved their case beyond a reasonable doubt. I cannot say as an attorney, and this is what kept happening. I cannot say, ladies and gentlemen of the jury, I know you heard all of this evidence, but don't believe any of it. Because what happened is everyone was upset that Tory decided to remain independent and Roc Nation wanted to sign him. But because Tory would not sign with Roc Nation, this is why they're making up all of this stuff. He never shot her. It was Kelsey. And then the jury is going to get a jury instruction that says anything that a lawyer says is not evidence. But as the lawyer, I have not put on anybody from Roc Nation to prove that he even was offered a contract, let alone that they was pissed about it. I have not put on anything where Kelsey somehow, or there was a witness, or somebody recorded it, or it was a conversation with Kelsey and she acknowledged it, where she was the shooter. You didn't put that evidence on. This is just your theory as an attorney, which means absolutely nothing. And I think that's what people are missing in this case. Just because I'm giving my opinion on why they prosecute does not mean that I'm on his side. I can't stand a little troll, period. And I'm glad that Meg Thee Stallion got justice. So you're saying, so you must have, I didn't see what you're saying, why you believe he got prosecuted. I do believe, to me, this was a 3-day trial. I will never understand why it took 2 weeks. Well, yes, I understand why. Because we would get there, they would start at 10:30. They would take a break at 12 for lunch. Lunch was an hour and a half. We'll come back at 1:30. They may start by 2, but it barely ever did it start on time. Then when that clock struck 4, or was it 5? It may have been 4 or 5. I can't remember. They were done. If you were in the middle of saying cross-examining somebody, the court would be like, okay, we're adjourning till the morning. So it wasn't like if you guys watched the Travis Rudolph case where they were doing 8 and 9 hour days. That's typically what you do. This was not a case that should have lingered as long as it did. It was just, so I don't know if it was the publicity of it. I don't know if this is just how this judge runs the courtroom. I don't know what it was about, but it was long for no reason, in my opinion. This man has a history of violence. It's not a big mistake where a person temporarily lost their mind, and it was one thing. It could have been, if he has all of this evidence that's out there, he should have brought it. That's all I'm saying. You cannot, how do you go on? And let me go to the sentencing amendment. So everybody knows that the prosecution by now has asked for 13 years. They provided what's called a sentencing memo as to why. So I've kind of read it a little bit, but not really. But I do want to go over the sentencing memo before we move on to Jose Baez actually trying to get the judge removed off of this case. I don't know. So this is the people's sentencing memo. So we're going to go through. We already went over the allegations and what the jury found. So let's go to the statement of facts. So all of you guys that may not be familiar and know the whole story. This is from the prosecution's perspective. This is what happened. On July 12, 2020, at approximately 4:30 in the morning, the defendant fired 5 rounds from a semi-automatic handgun at victim Megan P. The victim sustained gunshot wounds in both of her feet, which required surgery to repair. The shooting occurred after a social gathering in the Hollywood Hills hosted by celebrity personality Kylie Jenner. Among some of the guests in attendance were the victim, the defendant, and the victim's assistant and best friend, Kelsey Harris. At the time, the victim and the defendant were friends with each other, sharing a brief, intimate relationship. So at the time, and that was another thing, people were upset because Meg went on Gayle King's show and said that she did not have a relationship of that kind with Tory Lanez. So people, that was another reason why people felt like nothing she said should be credited, because she went on this show and she essentially denied an intimate relationship with him. But I don't know so many people that just want to put their personal business out there. But again, she acknowledged it when she was on the stand, and the government is acknowledging it here. So at the time, the victim and the defendant were friends with each other, sharing a brief, intimate relationship. The victim, the defendant, and Ms. Harris all left the party together. They got into a Cadillac Escalade driven by the defendant's security guard and driver, Jaquan Smith. And y'all know heard about Jaquan. He like showed up at the last minute. He had a bench warrant. This case was so dramatic. While Mr. Smith was driving the parties to their respective destinations, an argument ensued between the victim and the defendant. Ms. Harris intervened on behalf of the victim, accusing the defendant of disrespecting the victim. The defendant threatened Ms. Harris, stating he would shoot her as he reached towards the center console as if to grab something. The argument between the parties escalated. Mr. Smith pulled the car over on a residential road in the Hollywood Hills so that the victim and Ms. Harris could get out. The victim and Ms. Harris both exited the vehicle on the passenger side. As the victim was walking away from the car, the defendant produced a semi-automatic handgun and yelled out, "Dance, Biatch," and fired 5 rounds at the victim, striking her in both feet. Injured and bleeding, the victim crawled to the driveway of a nearby house. The defendant approached the victim in the driveway. He apologized for his actions and begged her not to say anything. He convinced the victim to get back in the car. Ms. Harris confronted the defendant for shooting the victim, which caused the defendant to physically assault Ms. Harris. He grabbed her by the throat and pulled her by the hair before calming down again. Ms. Harris sustained injuries as a result of the defendant's attack. So they actually showed pictures that were taken of Kelsey, which were allegedly bruises and marks from when Tory allegedly beat her up at the same scene. Now, as we know, Kelsey got on the stand and pled the fifth and acted like everything she said to the prosecutor and to the police before was all a lie. She took everything back. But if you heard that recording, she sounded way more convincing when she was there. She had her attorneys. She had her, I think it's her husband now. She had all these people that were there with her when she went to talk to the police. And then suddenly on the day when she gets on the stand, she takes everything back and says she lied. Now, this is the information that she gave the police when she went for her recorded interview, which we all know at first was going to be inadmissible. But then Tory's attorney started cross-examining Kelsey. And he did good at first. Like, to me, I was like, okay, I'm feeling him. But then he kind of went too far. So the court had already deemed that this audio was going to be inadmissible. That was the interview with the police. It was going to be inadmissible. Except used for impeachment purposes, of course, if she said anything that was contrary. But he ended up making it as if the prosecution somehow did something unethical that made her say the stuff that she said. It was like an inference that happened. Anyway, he opened the door. His cross-examination went so far that it opened the door. So now they were able to introduce this audio, which gives all this information about this alleged attack. All right. Everyone got back in the car. The defendant sat in the front passenger seat. The victim sat back seat on the passenger side, and Ms. Harris sat in the back seat on the driver's side. The victim was bleeding profusely from her injuries. Ms. Harris quickly sent a text message to the victim's security guard, Justin Edison, stating, "Help, Tory shot Meg, 911." That text message was shown and produced at trial. This is what I'm talking about, evidence. That text message was produced at trial from Kelsey's. Now, mind you, when she testified, she pled the fifth, and she also said she ain't seen nothing. She didn't see Tory shoot her or none of that. She took all that back. But this is a text message that says, "Help, Tory shot Meg." That text message was produced. A resident, and Kelsey also contacted, I think it was a sister and her mom. Like, she was trying to call people to let them know what was going on and where they were at. So it wasn't even just Justin that got some type of communication. A resident from the scene of the shooting reported the incident to the police, including a description of the car and license plate number. Officers located the car traveling in the area of Hollywood Boulevard and La Brea Avenue and conducted a felony traffic stop. Before officers approached the car, the defendant begged the victim and Ms. Harris to keep quiet. He offered them each a bribe of $1 million, which was met with disbelief and summarily rejected. The defendant also tried to bribe Ms. Harris a second time days after the incident, which was also rejected. And what they're talking about is the phone call. Everyone saw a phone call where Tory, which I didn't understand why he would even call Kelsey or feel like he could. He called Kelsey while he was in jail after this incident happened. And allegedly, he supposedly, I don't know if that was in a phone call. I know she mentioned it. Let me take that back because I don't remember and I don't have my notes. But somehow there was a conversation. No, I think that was when Kelsey and they all met up so Kelsey can get her stuff or her belongings that were in the car. But anyway, allegedly, Tory offered her money for her to start a business or do something like that. And then Tory alleges that he was phrasing it in that manner. He didn't just say, "Here go $1 million." He just said, "Do you need any way to start a business? Do you need any money for a startup?" And she made it as if Tory was offering it that way because his attorney, who at that time was Sean Holly, allegedly told him, this is how you need to phrase it, I guess, so it wouldn't seem like a bribe. This is according to them. That becomes important later because Jose Baez tries to use that to say that because this allegation came out, it made it seem like Sean Holly was in some form of impropriety. And that's allegedly why Sean Holly didn't want to represent Tory anymore, which was strategy because Tory, obviously she's a woman. And they felt like it would be a better look strategy-wise to have a female attorney as opposed to just have the male attorney. So because of this alleged bribe that supposedly came and was phrased in this way by the attorney, Sean Holly, according to Jose Baez, was saying that's why she didn't want to represent him anymore. However, the letter that we saw from Sean Holly said that she had a conflict, so she couldn't represent him because she was in an arbitration and she had a conflict. So Magdalene, who ended up representing Tory Lanez, he was already co-counsel, but he wasn't considered lead. So now he had to take lead. So they were alleging that he didn't have much time to prepare because Sean Holly was lead, so she was the one that would have been prepared for trial. Hope y'all got all that. Officers ordered the parties out of the car and conducted a search of the car. They recovered a semi-automatic firearm on the front passenger floorboard where the defendant was sitting. That was warm to the touch and found in a slide lock position, suggesting every round had been fired from the gun. Several spent cartridge cases were recovered from the scene of the shooting and were later matched to the handgun found in the vehicle. So there was a gun, there was bullets. The gun was found in the car. The gun was warm. That is what you call evidence. The victim initially told officers that she sustained the injuries to her feet by stepping on glass. This is what the big hoorah is about, because people are like, she lied. She lied because she said she stepped on glass. She was in shock, scared, and embarrassed about what had occurred. She was examined by attending physicians at Cedars-Sinai Medical Center for gunshot wounds. Several bullet fragments were surgically removed from both of her feet. 4 days later, once removed from the excitement of the situation and with a clear head, she told the truth about what had happened to her. Gunshot residue tests were performed on all of the occupants except for the victim, who was transferred by ambulance to Cedars-Sinai Medical Center. The defendant and Ms. Harris both tested positive for gunshot residue. The driver, Mr. Smith, tested negative. DNA testing was conducted on the recovered firearm, but the results were inconclusive. The defendant was detained for possession of a concealed weapon while the investigation to the shooting was ongoing. While detained in custody in less than 5 hours after the shooting, the defendant placed a jail call to Ms. Harris, which was recorded. He asked where the victim was being treated for her injuries and expressed deep remorse for his actions. He stated, among other things, that he, quote, made a mistake, end quote, that he, quote, can't take back, end quote, and that he, quote, never did that if I wasn't that drunk, end quote. He continued to say, quote, regardless, that's not going to make anything right. I never even move like that, end quote. He was concerned about names being released to the media, saying that the only person, quote, that's going to get this backlash is me, end quote. He acknowledged that the victim will, quote, probably never, ever going to ever talk to me ever again, end quote, but reiterated that he was just so effing drunk, end quote. After his release from custody and just hours later, the defendant then sent a text message to the victim reiterating the same apology, stating, quote, I know you probably never gonna talk to me again, but I genuinely want you to know I'm sorry from the bottom of my heart and I was just drunk, end quote. The defendant also texted, quote, nonetheless, it should have never happened and I can't change what I did. I just feel horrible because I genuinely just got too drunk. So if you guys don't know, the reason why people, based on this conversation, people are trying to say he was apologizing for sleeping with both. This is the pro-Tory people. Their argument is these texts are not referring to a shooting. These texts are referring to him actually blurting out during the argument that he was sleeping with Kelsey and Meg. That he had, because he slept with Kelsey first back in the day. That's who he first dealt with. And then he started sleeping with Meg, but Kelsey didn't know that Meg and Tory was sleeping with each other. So this is what the pro-Tory, the Tory people, their argument is that these texts that I just read have to do with him sleeping with them, not the shooting. And Jaquan showed up ready to testify, neither here nor Kelsey. That was per his own attorney and reporters. Yeah. All right. So defendant's conduct pre-trial. Defendant has been found in violation 3 separate times by 2 separate bench officers for his pre-trial conduct. As previously cited in our pre-trial motions, the defendant released an Instagram live video in October 2021 claiming that the victim was pushing a, quote, false narrative and repeatedly suggested that the victim was lying about being shot. As a result, the victim received intense harassment online from members of the public. Then on July 25th, 2021, the victim performed at the Rolling Loud Festival in Miami, Florida as a scheduled performer. Scheduled to perform immediately after the victim was Jonathan Lindell Kirk, professionally known as the Baby. This is funny how I don't know none of these people. Like, who? Okay. This was a highly publicized event attended by roughly 75,000 people. The defendant was not a scheduled performer. During the victim's performance, the defendant went through security clearance and entered the green room. These areas were within 100 yards of the stage where the victim was performing, in violation of the protective order. It was also brought to the victim's attention that the defendant and the baby attempted to rush the stage during her performance. In no way was the victim previously aware of, nor did she consent to the defendant's presence at the venue when she would be performing. The victim was incredibly fearful upon discovering the defendant was at the venue and within the prohibited 100 yards. Media reports documenting the defendant revealed at RLF after the victim's performance soon followed. Days later, upon being asked online, quote, "Don't you have a gag order?" end quote, the defendant responded via his Twitter account, quote, "I'm starting not to give a F," end quote. Oh, Tory, come on. On August 23rd, 2021, the Honorable Keith Bourgeon in Department 31 found the defendant in violation of the Criminal Protective Order. The defendant's bail was increased to $250,000, and the defendant was ordered not to attend any event in which the victim was already scheduled to appear. Judge Bourgeon strongly admonished the defendant, advising him that further violation will result in remand. On April 5th, 2022, this court found the defendant in violation of the Discovery Protective Order. In support of the people's motion to revoke bail, evidence was presented to show the defendant posted a series of tweets to his millions of followers on Twitter, which disclosed discovery, the LAPD DNA report that was subject to the Discovery Protective Order. The defendant also publicly tweeted derogatory statements towards the victim, stating, "Good DICKA had me effing two best friends, and I got caught. That's what I apologized for. It's sick how you spun it, though." The defendant's tweets caused significant harm to the victim, and she received numerous threatening messages as a result, including messages from the public suggesting that she should be shot. Oh my gosh. The court increased the defendant's bail to $300,000. Did y'all notice that he had all these violations and then that the court just kept on increasing this bail because of this type of behavior? What? He was just like, he told the court order, "You can get the finger, the middle." The defendant's tweets caused significant harm to the victim, and she received numerous threats, messages as a result. The court increased the defendant's bail to $350,000, and the defendant was briefly remanded to custody before posting a new bond. The defendant was further ordered not to publicly discuss the victim. So then that's when the gag order happened, I presume. On October 26, 2022, the court placed the defendant on electronic monitoring due to evidence presented by the people that the defendant physically assaulted another individual, musical artist August Alsina, on September 17, 2022, while pending trial. In support of the people's motion, the people provided this court with reports, recorded interviews, and video recording of the night in question. After Mr. Alsina neglected to shake the defendant's hand, the defendant followed Mr. Alsina outside of a venue where a verbal exchange occurred. The defendant was accompanied by several members of his entourage and security team, easily outnumbering Mr. Alsina. As Mr. Alsina briefly took his eye off the defendant sucker punched Mr. Alsina on the left side of his face, knocking him to the ground. The defendant was wearing several rings on his fingers at the time he punched Mr. Alsina. Mr. Alsina sustained an injury to his mouth, arm, and knee and was bleeding profusely. Mr. Alsina also believed he may have sustained a concussion. I don't even know what to say. See, I was just watching the trial. I didn't even know all of this. This wasn't really talked about. So now they talking about his conduct post-trial. Hold on 1 second. I don't want to blow my nose in your face, But I do have a little cold here. But anyway, let's go on to the post conduct. We just talked about the prior conduct, pre-conduct. After the defendant was found guilty by 12 jurors on all counts and allegations on April 21st, 2023, defendant released an Instagram post to his roughly 11.9 million followers making unfounded accusations about the people, claiming both assigned prosecutors hid and suppressed exculpatory evidence and manipulated false narrative. Y'all remember that? Because we talked about that over here. I wonder if I still got that. Let me see. Hold on. Let me see. Hold on.
I've been incarcerated for almost half a year over a gun that the DAs lied and said I shot. In 2021, they demanded I take a DNA test. I took that test with no pushback, delay, or question. Not only because I knew I never shot the gun, but mainly because I was 100% positive I never even touched this gun. In my trial, the verdict of guilty or innocent depended heavily on my DNA results. With the help of LA Crime Lab's DNA expert Randy Zepeda, DA Kathy Tarr and Alex Bott completely manipulated my DNA results and lied to the world, the media, and most importantly, my jury, by stating my DNA on the gun was inconclusive. That was an absolute lie. They went on further to say, inconclusive means that he cannot be excluded from the gun. My new attorney, Jose Baez, hired one of the best DNA experts in the nation to carefully analyze the same DNA test the fair and correct way. The results came back exactly as I knew this whole time. My DNA is 100% excluded and 100% eliminated from the gun. In other words, it's physically and scientifically impossible for me to ever have touched or shot this gun. After the correct and careful analyzation of my DNA testing, not only did our expert find my DNA 100% excluded and non-existent on the gun, but what's worse was the invalid and illegal tactics the prosecution chose to attain the results used to convict me. Based on the fundamentals of my DNA test, the only possible way for the LA Crime Lab to come up with an inconclusive result would literally be to stop the testing before it finished or completed its final result, which would have and should have shown completely my full exclusion on the weapon. In other words, District Attorneys Kathy Tarr and Alex Bott lied to my jury with false, incorrect, and incomplete DNA results, violating my due process and my 14th Amendment rights. My faith, my prayers, and my highest hopes go to the Honorable Judge Hereford that on May 8th, he rules in favor of the United States Supreme Court law, returning me to my freedom, my family, and most importantly, the justice of a fair trial.
So that was the first recording that came out, and we talked about that because I was like, why is your attorney allowing you to talk like this? I really had that question. And then, wait a second. This was another one. It was more. So let's do that one too. Let's see.
Dear George Gascon, I write this message with the utmost humility, love, and respect for the remarkable steps that you've taken in regards to fighting for the justice of Black and brown minorities. Today I take a stance as an innocent black man, wrongfully convicted of a crime I did not commit. I've watched 2 district attorneys from your office by the names of Kathy Tarr and Alex Bott unlawfully misuse their authority to hide and suppress any and all exculpatory evidence that exonerates me and furthers my innocence. I was completely robbed and deprived of a fair trial. So on May 8th, my lawyers will be arguing a motion for a new trial. Not only do I owe it to myself to fight for my freedom, but I owe it to my 6-year-old child, my family, my fans, and most importantly, the hundreds and thousands of Black and Hispanic minorities that cannot adequately fight for themselves. For 3 years, the prosecution has manipulated a false narrative that has left me with no choice but to expose the practices, the behind-door deals, and the unjust system that was used to illegally convict me and countless other minorities. We elected you because of your outstanding eminence in making fair and correct judgments in the justice for people of color. So, Mr. Gascon, I come to you today as a wrongfully convicted Black man, not asking for sympathy nor compassion, but for you to simply do what is fair and right in the laws of California, and most importantly, in the eyes of God.
So for those that missed that, that's what she's talking about, or the prosecution is talking about in this sentencing memo that we're talking about right now. So let's go back now. So they say, defendant released an Instagram post to his roughly 11.9 million followers, making unfounded accusations about the people, claiming both assigned prosecutors hid and suppressed exculpatory evidence and manipulated a false narrative. On April 25th, 2023, the defendant doubled down on his false accusations and again made unfounded statements on Instagram that both assigned prosecutors, quote, lied about the defendant being the shooter. Quote, manipulated the DNA results, end quote, with the LAPD expert Randy Zapata. Quote, lied to the media, the world, and the jury, end quote, and used, quote, invalid and illegal, end quote, tactics with respect to the DNA evidence. The defendant then falsely claimed that his newly retained DNA expert suggested the only possible way the results of the DNA would have returned inconclusive would have been if LAPD had deliberately stopped the testing before it was completed. That's what we just heard. He did say that in those recordings, that his lawyer must have said it was okay to release. Defense, well, maybe his lawyer didn't say it was okay. So I'm gonna take that back. Maybe that was something he did on his own, because the gag order was released, was lifted. I think when he had David Kenner earlier this year, David Kenner filed a motion to try to have the gag order lifted, and it was lifted. So maybe he did this on his own. Defense expert Eichenboom provided a declaration to this court in support of defendant's motion for new trial and made no such claims. Defense expert Eichenboom in his declaration essentially reviewed the same DNA reports previously reviewed by both the defense and prosecution DNA experts who testified at trial and rendered a different opinion as the results. Impact on the victim. The victim testified at trial about how the defendant's actions on the night of the shooting and the 2 years that followed have impacted her life. The victim talked about how the defendant and his followers posted false information online about the incident in order to get ahead of the story. The defendant fueled those flames when he suggested in his derogatory tweet that this case had something to do with the victim's sex life. The victim testified that people called her a liar, shamed her over her sex life, and even sent her death threats. And now, in her own words, the victim stated, I feel like I can't even hold a conversation with people for a long time. I don't want to talk to my friends. I don't want to talk to my man. I don't want to talk to anybody to ask me about this. I feel terrible talking about it. I feel like I have started to feel like because I don't matter, I don't even want to be on this earth anymore. I wish he would have just shot and killed me. I would have known I was going to go through this torture. The defendant is ineligible and unsuitable for probation. Pursuant to Penal Code Section 1203, except in unusual cases in which the interest of justice would best be served if the person is granted probation, probation shall not be granted to any of the following persons. Any person who used or attempted to use a deadly weapon upon a human being in connection with the perpetration of the crime in which that person was being convicted. and any person who willfully inflicted great bodily injury in the perpetration of the crime in which that person has been convicted. A jury found true allegation that the defendant personally used a firearm in violation of the penal code and personally inflicted great bodily harm to the victim. So basically, they're saying he ain't ineligible for probation. So let's just get right on to the years. That's what they're saying, because they say probation is not an option under the law. The court should also find the defendant unsuitable for probation based on his conduct before this court. The defendant's repeated unwillingness to comply with court orders throughout the pendency of this case demonstrate his complete disregard for the court, the victim, and the safety of the public. The defendant has already been verbally admonished, remanded to custody, and had his bail increased by a significant amount for several violations. The fact that the defendant committed another unprovoked attack on another person, August Alsina, while he had a violent felony case pending before this court speaks volumes. The court gave the defendant opportunity after opportunity to comply with the court's order, but the defendant remained undeterred by the court's efforts to regulate his conduct. His history of noncompliance with this court is an indicator of future noncompliance were he to be placed on probation. To say that the defendant simply failed to obey perfunctory court orders would be a gross understatement. The defendant was defiant. His violation bordered in intimidation and harassment of the victim and could have potentially jeopardized the sanctity of the proceedings. The court may also consider the defendant's lack of remorse as a basis to deny probation. The defendant has failed to exhibit any remorse, which begs the question whether any of the apologies he directed to the victim in a text message and jail call were genuine and not just driven by an effort to maintain her silence. Except for the jail call admission and his apology text to the victim back in July 2020, the defendant has spent nearly 3 years since that time waging a campaign of misinformation to re-traumatize the victim. Profiting from his crimes, he released a full-length album with several songs about the shooting, one of which included the following lyrics, quote, "Gotta see a couple of questions. How the F you get shot in your foot? Don't hit no bones or tendons," end quote. He released an Instagram video in 2020 suggesting the victim was lying about being shot. He was complicit in the selective release of DNA discovery in violation of the Discovery Protective Order. He posted an inflammatory tweet regarding the victim, suggesting she had, quote, spun the story, and this case was about his sexual relationship with 2 women. So then right here in the footnote, they had lyrics from Money Over Fallouts, a song featured on the defendant, a full-length album, Daystar, released in September 2020. This is one of many specific references to the night of the shooting and to the victim. That's in a footnote. After the defendant was found guilty, he attempted to undermine the jury's verdict by falsely accusing the prosecution team of falsifying and suppressing evidence without any basis in fact or reality. The people are not suggesting this court penalize the defendant for not accepting a plea deal. However, the people ask this court to consider that the defendant's actions go beyond him exercising his right to a jury trial. The defendant actively invited harassment of the victim by spreading misinformation to his large following in an effort to galvanize the public against the victim and even the prosecution team without any regard to the dangers it posed to the parties nor the impact it would have on the victim. The defendant has weaponized misinformation to his large following to such a degree that it has left a lasting traumatic impact on the victim. The defendant not only lacks remorse, he is clearly incapable of accepting any responsibility for his own actions. The defendant lacks remorse is insidious, leaving this court no assurances that the defendant will not repeat this type of behavior in the future. Wow. So then they go through the aggravations again. We went over that in the beginning, so we don't have to go through that again. The aggravating factors. So let's go. In the instant case, the recorded jail call to Ms. Harris and the apology text to the victim was tantamount to a confession. The defense argued unconvincingly at trial that the jail call and apology text were apologies about the defendant allegedly sleeping with both Ms. Harris and the victim. The entire jail call and apology text, when viewed together with the other evidence presented at trial, can only be rationally interpreted as an apology for the defendant shooting the victim. The defendant admitted guilt. As such, his lack of remorse can be appropriately considered by this court as an aggravating factor. So they did aggravating factors, and then they do mitigating factors, which would be those factors that could reduce the punishment. Oh, man, this is... So they did the circumstances of mitigation. Let's go over that real quick, and then I'm going to get to your questions and your comments. So California rules of court. The defendant has only one statutory circumstance in mitigation for this court to consider. Although he has no prior record of conviction or an insignificant record of criminal conduct, considering the recency or frequency of prior crimes, the defendant received a grant of diversion for a gun possession charge out of Florida. Because the circumstances in aggravation outweigh the circumstances in mitigation, the defendant should receive a sentence greater than the low term in state prison. Computation of the sentence. So the people respectfully recommend this court sentence the defendant as follows. Count 1, 6 years. 4 years for count 2, plus 3 years for 6, 7. See? So they're asking an aggregate sentence of 13 years in state prison. As to count 2 and count 3, the people recommend the midterm as to each count to run concurrent to count 1. Okay, so that's not really... So, wait a minute. Hold on 1 second. So, I'm sorry. So really, even though they're asking for 13 years, they are asking that the count 2, which is 4 years, and count 3, which is 3 years, be ran concurrently with count 1. So really it's 6 years because they'll be running at the same time. If they said consecutive, then it'll be you do 6 years, then you do 4 more years, then you do 3 years. So that'll be 13 years. But because they're asking them to run concurrently, they're asking these two to run at the same time as this, which will really be 6 years. Y'all got it? So people are saying the 13 years. See, this is why I wanted to read it while you guys were on here. They saying 13 years, which is the aggregate sentence. That means all of them together. But they're asking, as you see here, the people recommend that each count run concurrent to count 1. Count 1 is 6 years. So you said concurrent is generous. It should have been consecutive. Excuse me. I could be wrong, but I don't recall seeing or hearing that he was there at the trial with her. I'm not saying he wasn't supportive, but I just seemed to be minimal. I'm assuming you're talking about her boyfriend. I didn't. I'm coming in being nosy at the end of conversation, so I'm pulling up half conversations. I'm sorry. So that is what the government is requesting. From my understanding, there was a tweet by Megan Kniff who asked who made this following statement. Wait. Did I put that up there? Wait a minute. Hold on. She made a tweet where she stated, just in, this was on June 8th, prosecutors anticipate Judge Hereford will grant Tory Lanez's request to continue his sentencing next week over their objection. A new date will be set then. So according to this tweet from Megan Cuniff, the sentencing may not happen on Tuesday. They are going to ask for a continuance. Now, you said his stance don't read definitely. I heard a lot of people say that 13 years, and that's why I really just read that for the first time. I heard the 13 years too. That's why I said that in the beginning. Like, I know you guys probably heard that 13 years is being asked, but as you guys see, they're not asking for them to run consecutively. They're asking for them to be ran concurrently. All right. Now, in the midst of all of this drama, while he's awaiting sentencing, and I'm not saying that he has to admit that he did it if he really didn't do it. The evidence, the jury believes you did it after all of the information that was out there. But if you have some additional information that can prove your innocence, that's what you should be focused on right now. You should be focused on new evidence that may not have been available at the time of trial in order to help any potential of you not going to jail. Now, mind you, he's already been in for like 6 months. He's been in since December, January, February, March, April, May. Yeah, he's been in for 6 months. So he's already done a nice little chunk. So my personal opinion, again, this is just my opinion, I feel like he should be focusing on finding something that will confirm what he's saying. Because what he was saying in those messages ain't it. That's not it. Worrying about DNA and what inconclusive means, and they gave false information and they scope, because you got a lot against you. Because then you defied the orders. You were like F the orders. You were out on bond, and then they had to up your stuff to 250, then up it another 100. Like, you got a lot that's going against you. But anyways, because the judge has made the rulings that the judge has made, his attorney found that he wanted to file a motion to dismiss the judge. I mean, he wanted to get a new judge on the case. So Jose Baez filed a motion trying to remove notice of defendant's motion to disqualify the judge for cause. So it's 15 pages. I'm not going to read it all. Well, but this motion was filed, and I believe it was heard. I actually have the transcript, but the transcript is so long that we definitely can't go through that. But let's go with his memorandum of points and authority. Defendant Daystar Peterson respectfully moves this court to disqualify for cause the Honorable David Hereford, judge of the above court, from the hearing and determining of this matter on the grounds of prejudice against Mr. Peterson by the terms of Civil Procedure Code Section 170.1. Mr. Peterson respectfully requests that the court grant his motion to disqualify judge for cause. Then he goes on to Section 170.1 that provides that a judge shall be disqualified where, 1, the judge believes that his recusal will further the interest of justice. 2, the judge believes there's a substantial doubt as to his capacity to be impartial. Or 3, a person aware of the facts might reasonably entertain a doubt that the judge would be impartial. So then he goes on to say, although judicial rulings and opinions on the facts generally do not constitute a valid basis for a bias or partiality motion, disqualification may be required where such rulings and or opinions reveal an opinion that derives from an extrajudicial source and will require reversal if they reveal such a high degree of favoritism or antagonism as to make fair judgment impossible. So This is their background facts. Now that we kind of generally know what the standard is to disqualify a judge. During petitioner's motion for a new trial, petitioner was deprived of due process of law. Petitioner Daystar Peterson's deprivation of his due process was by way of inherent judicial bias and intentional and deliberate agenda to dismantle petitioner's defense by the court in a manner that a person aware of the facts might reasonably entertain a doubt that the judge would be able to be impartial. Mr. Peterson avers that judicial activism and substantial prejudice against any party or attorney or the interest of the party or attorney as presented here has denied him a fair and impartial hearing on the motion for a new trial. In support thereof, declarations by Mr. Peterson's attorneys are forthcoming and states as follows. So then he goes on to all these incidents. So there was April 10th, 2023 chamber conference. I only had one time where I was on a case, and I think it was a divorce case. And because the judge was ruling in my favor, it wasn't because he liked me. I was probably 1 year out of law, off the bar. I was so new. He was a seasoned attorney. But because I was so new, I always made sure that I crossed all my T's and dotted my I's. And I knew the law. I would stay up all night to make sure I knew the law. And I just had a good case. And the judge ruled in my favor. He did a motion to disqualify this judge saying he was favoritism towards me. I'm like, he don't even know me. I literally just started. It was my first case. And what happened is my mentor was older. She was like in her early 70s and she was still practicing. She called like the night before and she was hysterical because she thought this case was going to settle. So she said, "Hey, Pam, I got a trial tomorrow on this divorce case." And she said, and I thought it was going to settle because they said it was going to settle, but it's not. And I'm just so concerned because I'm 70 years old. I don't try cases. That's pretty much what she said. So I said, "Listen, I'm fresh off the bar. I can't guarantee I know what I'm doing. But if you send me the documents, I'll review them." And I literally went into that case, that it was the next day. And I did a whole trial and had no clue. I had never met the client before that day. I didn't know what was going on in the case. I didn't know anything. And I remember walking in that trial. And the guy, the attorney was like, "You look like you fresh off the bar." Like he was trying to intimidate me. And he was absolutely right. Like I was fresh off the bar. And so that's the only time. And it was just crazy to me because I just worked really hard because I didn't have, I didn't have the experience. And so I worked harder because I was new. And he was just like, couldn't believe I was winning. Like he tried to intimidate me in the beginning. And I was smacking him around that courtroom. And I even got attorney fees off of that. So that was the first time, and he was mad. But anyway, I digress. So let me get back to his motion real quick, and then we're going to hop off of here. Hold on one second. I'm just going to go over some of his reasonings. On or about April 10, 2023, this court called and held a hearing proceeding by a chambers meeting with all parties or their attorneys of record. In attendance for the people during the April 10th meeting was Ms. Kathy Taw and Mr. Alexander Bott. In attendance for Mr. Daystar Peterson was Mr. Jose Baez, Mr. Matthew Barhoma, and Ms. Christine Benevent. So they added a woman to the team. During the meeting in chambers, the court inquired as to offer of proof of petitioner's Sixth Amendment violation and violation of petitioner's right to counsel. The court further inquired for an offer of proof for all witnesses. The petitioner intends to cause continued hearing for a motion for a new trial. Okay, let me go through because this sounds like it's about to be long. So they went into chambers. And they were trying to see how they were going to present this evidence at this motion for a new trial. Okay, they talk about soliciting more briefing. Okay, let me go to May 8th. This is the day of the actual hearing. So on or about May 1st, 2023, the petitioner supplemented his filings with the necessary declarations. Due to the limited time available to obtain the transcripts of the May 8, 2022 hearing on the motion for a new trial, the following facts only reflect the issues presented during the morning proceeding. Within the first 2 minutes of the proceeding, Judge Hereford had already made abundantly clear this would be a biased hearing. While stating that legal standard for a new trial, Judge Hereford emphasized Article 6. You okay? Mm-hmm. Okay. Article 6, Section 13 of the Constitution, which was cited by the people. Here, turn around so I can put you back. Sorry about that. Which was cited by the people, and contrary to the court statement, this exact citation was also cited by Mr. Peterson in his motion for a new trial. This not the only time during the hearing where the court exhibited its failure to read the defendant's motion. And yet, rather than allow Mr. Peterson to litigate the matters in the order that his counsel deemed fit, the court pressed and demanded the defense present its argument in the same order presented in its motion. This was done over defense counsel's objection. Furthermore, the defense highlighted the importance of beginning with the issue regarding the conflict of interest for due process purposes and judicial economy. Moreover, defense counsel emphasized the unfair prejudice exhibited by the court by limiting Mr. Peterson's ability to present his case in the order that he deemed fit in accordance with his legal strategy. This act was contrary to prior displays of judicial fairness that the court showed to prior counsel Sean Holly Esquire. For example, during a pretrial hearing on April 5th, 2022, while the court heard an issue revolving a DNA leak in violation of a discovery protective order, the court directed prior counsel to the first issue as follows. The court, so why don't we address that issue first? Ms. Holly, thank you, Your Honor, and I appreciate the court wanting to take them separately, but if it's okay with the court, I kind of need to mix them up a bit. The court, all right, that's fine, we can do that. So now they're complaining because they wanted to present their argument in the order they wanted to present it, and the court asked that they present it in the way their motion was. And they're saying it's unfair because what Sean Holly was representing him, and there was the issue on the discovery leak, she was able to argue her case in the manner she wanted to. So rather than show defense counsel the same respect and fairness exhibited to prior counsel, the court disregarded every argument and objection raised in regard to the order of that issue, would be presented and stated, okay, I don't think either one of you is listening to what I'm telling you. We're going to go through the arguments one by one, i.e. starting at issue 1. Ms. Holly is involved in the conflict of issue matter in this case that defense counsel sought to address first because the rest of the issues stem from the conflict interest raised in Mr. Peterson's motion. Moreover, the court repeatedly emphasized objections that were allegedly waived while choosing not to address errors of law or dismissing arguments regarding why certain issues raised due process concerns were not waived. For example, the court stated that he read the moving papers very thoroughly. However, that is negated by the fact that the court was unaware that the defendant had raised a Sanchez violation regarding the Instagram post that was admitted in this case. The Sanchez violation was addressed in defendant's motion, yet when raised at hearing, the court surprisingly stated, wait a minute, hold on, you're saying this is a Sanchez violation? Rather than allow Mr. Peterson to present his argument regarding why this was indeed an error of law under Sanchez, the court circumvented back to an argument based on another issue regarding the discovery violation and then immediately proceeded to the second issue. Moreover, the court disregarded Mr. Peterson's argument that the alleged failure to object to the DNA evidence was not waived, pursuant to the comment section of Evidence Code Section 353, which states the Evidence Code 353 is subject to the constitutional requirement that a judgment be reversed if an erroneous admission of evidence resulted in a denial of due process. Although the judge emphasized numerous times that the people were relying on Section 353 of the Evidence Code in support of forfeited objections, the court dismissed Mr. Peterson's argument as to why certain objections were not raised. So let's go to his argument. Judge Hereford made several judicial rulings and expressed opinions which will lead a reasonable member of the public at large, aware of all the facts, to reasonable entertain doubts concerning the judge's impartialities. These rulings and opinions reveal such a high degree of favoritism or antagonism as to make fair judgment impossible. First, the judge has placed severe restraints on the manner and order in which the defense may present the case. What? Well, you're going to be hit if you go to the Supreme Court, the United States Supreme Court, or if you go to the Court of Appeals, because you could have your nice, pretty speech already laid out, and then they stop you and they jump all the way to the 8th part of your notes, and then you got to answer their question, remember what was said, and then go back to your argument, and then they start shooting questions at you like this. That's what the appellate courts do. So I don't understand this argument. Okay, I'm going to go on. Present in the same order. Okay, that's what he's talking about. Okay. Third, the judge has repeatedly interrupted and cut off Mr. Peterson's attorney during oral arguments. Didn't I just tell y'all that's exactly what they do? You literally go before them. And then what they do is they say, go ahead, counsel. Present your argument. Good afternoon, Your Honor. May it please this honorable court, Ham Esquire appearing on behalf of defendant A. Your Honor, I just want to let you know that this is a pure constitutional violation. His Fourth Amendment rights have been they cut you say bye, and they stop. Counsel, how are you saying that? Da 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 da. Counsel, how do they do that? That's exactly how oral arguments go. They cut you off because there's an assumption that they read your brief. Or you start out and you'll say, well, Your Honor, I know that you're a diligent judge, and I know that you have read my brief. So do you have any questions for me? Because I already know you're about to cut me off anyway. You don't say that, though, but that's why you say that. Exactly. That's what it sounds like to me. It sounds like the judge was trying to have control and run his own courtroom, and Jose Baez said, I am that guy who represented Casey Anthony, and this how I want to do it. But the court could run their court how they want to. So let me see if he say anything else. Let's see how he cut him off. For example, after defense counsel's repeated emphasis on the importance of beginning with the issue of conflict, the court stated, okay, I don't think either one of you is listening to what I'm telling you. We're going to go through the argument one by one. Conversely, the judge has given the people a full and fair opportunity to present arguments uninterrupted, even when the case cited by the people did not stand for the proposition that they advanced. Moreover, the court emphasized the people's citation and dismissed counter-arguments presented by the defense. The judge's bias is further shown by his failure to address the Sanchez violation when it introduced the first issue regarding the improper admission of the Instagram post on May 8th. Instead, the court only highlighted the issues that the court had deemed waived rather than the error of law, which was preserved as an error of law. Furthermore, this is another example of the court's bias is not allowing the defendant to preserve the record. But did you say, it's been times I've had to say, Your Honor, I respect what you're saying, but I just need to preserve the record for appellate purposes. Sometimes you do have to tell some judges that cut you off so much that your entire argument does not get on the record. But you also have your brief that you can use for appellate. You can't bring up new issues for appellate purposes, but you can bring up those issues that you already addressed. And you just say, Your Honor, respectfully, you know, as an attorney, I am zealously advocating for my client, and I need you to allow me to preserve the record. And most judges will say, cool. Anyway. Together, these facts reveal such a high degree of favoritism or antagonism as to make... Danielle, hush, I'm on live. Together, these facts reveal such a high degree of favoritism or antagonism as to make a fair judgment impossible. Given these facts, a reasonable person would fairly entertain doubts concerning the judge's impartiality. As a result, disqualification is required. Even if this court does not find that disqualification is required under section, he may nonetheless recuse himself if he believes that recusal would further the interest of justice. So they said, even if you don't want to do that, maybe you should recuse your own self. That's pretty much what they're saying. So the judge responded, and pretty much I'm going to go to his conclusion. This is what the judge did, his ruling. Order striking statement of disqualification. I'm just going to go on to the conclusion. Since the statement of disqualification on its face discloses no legal grounds for disqualification, it is order stricken. Pursuant to Code Civil Procedure Section 170.4, the parties are reminded that this determination of the question of the disqualification is not an appealable order and may be reviewed only by writ of mandate from the Court of Appeals, sought within 10 days of notice to the parties of the decision. Code of Civil Procedure 170.3, in the event that a timely writ is sought and an appellate court determines that an answer should have been timely filed, such answer is filed herewith. So the court struck it, said, get this out of my, whatever. But you already know they filed a writ petition. So Jose Baez, when the court struck his request to disqualify the judge, he filed in the Court of Appeals a petition for writ of mandate. And what y'all think the Court of Appeals said? What y'all think the Court of Appeals said?
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Got it?
But you know what? Oh, I can't. That was a good one, though. That was a good one. So, no, seriously. This is what the court said. Let me get serious here. Let me see. Let me stop sharing. Because essentially in the appeals, of course, he raised the same issue. So I ain't got to go through all that. But he said, let me see. The Court of Appeals says, we have read and considered the petition for writ of mandate filed May 19, 2023, the application to appear pro hac vice filed by Jose A. Baez on that date, and the amended application and proof of service served and filed on June 6, 2023. The application to file an oversized brief filed on May 19th, and the request for stay of proceedings filed on June 1st. We disregard the application to file the oversized brief because it was not required. Petitions for writ of mandate are not limited to 10 pages. Danielle, over there. The application to appear pro hac. Let me cut this off. Hold on.
Ouch. Bobby, it hurts. See?
It's time to get off of here now because she's just touching stuff. Can't even read it. We disregard the application to file an oversized brief because it was not required. Petitions for writ of mandate are not limited to 10 pages. The application to appear pro hac vice is granted. The petition for writ of mandate and request for stay are denied for failure to demonstrate entitlement to extraordinary relief. So that was the court's response. That's it. Whoever you are, I don't know who you're saying is biased. I was there and I saw the case. So, have your mans come with some arguments. That's all I'm saying. Come with some arguments. I'm not talking about hypotheticals. I'm not talking about what you think. I'm not talking about innuendos. I'm talking about real evidence, the stuff that you need in court. That's what I need. People will always say judges are biased because honestly, and people won't tell you this, it's times that judges come in and they just mean for no reason. They had a bad night, but they are equal opportunists. That's why when I heard about this, I specifically asked, I said, were they just mean to them or was the judge just mean, period? Because sometimes they come in and they had a bad night and them and their wife was fighting and you catch it. And then you have some judges that come in and they like, didn't you what does a grant his motion to stay for sentencing mean? Tell me what that means. Because again, I'm asking, look, I don't have no problem with people with opposite opinions. What I'm saying is people are out here windmilling and have not come with evidence. We already played what Tory is saying his evidence is. That's not evidence. It's just not. To argue that a judge's bias that is holding your sentencing in his hands is not the smartest move, in my opinion. And I'm entitled to that just like you're entitled to yours. And I don't know if the court granted is. I just put the tweet up from Megan Cunin, who follows the case, and she said they think that they're going to postpone the sentencing. I don't know why they're going to postpone the sentencing. We don't know. Okay. Yep, give me 1 minute. Hold on 1 second, guys. Sorry, guys. Dev is at work, and I have to be a single parent for a week because he's out of town, and it is kicking my butt. I'm not gonna lie, it's kicking my behind because that is a daddy's girl. But anyway, I'm gonna holler at you guys later. I think my time is up because now she wants my attention. Thank you guys for rocking with me, despite all of these distractions. Oh my goodness. Listen. Oh my goodness. I'm like, what is going on? Yeah. But anyway, thank you guys for rocking with me. I'm going to holler at you guys next time. Welcome to everybody that has recently subscribed. We have a lot of new subscribers. Welcome, welcome, welcome. And welcome to those ones that have been rocking with me. You guys enjoy the rest of your Saturday. I want to come back later on if time permits, and then however my daughter is, it's gonna be up to her. But I do have the arraignment of the lady that shot the mother of 4. I do have her arraignment and her bond hearing, and so I want to go over that with you guys probably later on tonight. If you guys are down, please make sure you hit the like button before you leave up out of here, and subscribe if you haven't done so already. And thank you guys. Thank you. I see. I felt like it was Justin. I didn't agree with it, but still his opinion. Yes, everybody's entitled to their opinion. But my issue is people just don't come with facts. I don't care. I don't have a dog in the hunt, like I said. My thing is, instead of focusing on all these different motions and all of that may not have teeth, based on what I've seen, in my opinion, focus on if you got some stuff we have not seen. If you have new evidence that we have not seen, that is a cause for you to file a motion. That is a cause that can help you get out. Focus on that. That's all I'm saying. See, people get so focused on public perception and what the public feels. And the public doesn't matter. I don't care if 5,000 people come in my chat and they start saying boo and putting potatoes in it. It does not matter. It does not matter. At the end of the day, the only thing that mattered was that jury. So him going on Twitter and all that stuff just came back to bite him in his sentencing memo. So this should be a lesson. You don't litigate cases in the media. You litigate cases in the courtroom. You follow the rules, and because that stuff can be used against you. They used everything he did pre and post conviction against him in the sentencing memo. It didn't help. It didn't help. But anyway. All right, guys, I'm going to talk to you next time. I got to go ahead and be mommy. I'm going to do this intro one more time.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.